Hi, everybody. Welcome to the Impact at Scale podcast with Zal Dastur. My guest today is Ryan Schermerhorn, who's a partner at Marshall, Gerstein and Borun, a law firm in the United States. Welcome to the show, Ryan. Sorry if I butchered any of those names.
No, you did well, and I'm used to my last name being butchered. So thank you for having me.
So, Ryan, this is the first time I've had a lawyer on my show. And typically we speak to people that are involved directly in climate, and you are, and that's why we brought you on. So can you tell me a little bit about your work in climate and what you're doing there?
Yeah, absolutely. So I am a patent attorney at the firm that you mentioned, Marshall Gerstein Borun in Chicago. And over the last few years, we've seen a growth in innovation in the clean tech space. And it's something that's of interest to me because I think it's, we have a number of countries that have met, together for many years now and have made pacts about reducing emissions and things we need to do to get there. I think at the end of the day, the only way we're going to get there is through innovation. And so we've seen a growth there. Our firm has seen tremendous growth in terms of all types of clean tech innovations, whether that's energy storage, hydrogen technologies, biofuels, additive manufacturing, recycling, carbon capture, and it's something that's very interesting to me. And there's some resources that the U.S. Patent Office offers that allow our clients to expedite the examination of their clean tech innovations, and so that's been exciting and something that I'm hoping to talk more about today.
I mean, that is such a, and forgive me, my voice is a bit gone today, but that is such a relief to hear that there is this surge of innovation in these areas, because I'm with you. I think that's one of the most crucial ways that we can solve this problem. When did you start seeing this occur? When did you see the growth occur?
Yeah, I think we've seen it kind of ebb and flow over the last 15 years, and the statistics bear that out. I think under the Obama administration in the U.S., we saw a growth, and then I think, we had a decline probably in the mid 2010s, and then just before COVID, I would say, we've seen a resurgence, and of course the Inflation Reduction Act, the CHIPS Act, to a lesser degree, I think provided some financial support for some of this R&D and innovation, and so yeah, I would say about the last 4 or 5 years, we've really seen a significant growth.
So the program that you're speaking about is the Climate Change Mitigation Pilot Program that the U.S. Patent and Trademark Office has implemented. Can you just tell me a little bit about the program, and then how important is it in streamlining the patent process for climate tech?
Yeah, so this program actually builds off of something that was started in the I think it was 2008, 2009, right around when I started practice. That was called the Green Technology Pilot Program. That ended in March 2012. This program was launched in 2022, and it is scheduled to last until 2027. So about a 5-year period for this program where applications that contain claims, and I guess not to get too much into the weeds, but claim in an application is effectively what defines kind of your legal scope of protection. So as long as those claims are in some way directed to mitigating climate change, whether that's removing greenhouse gases that are already present, whether that's reducing or preventing additional emissions, or monitoring, tracking, verifying greenhouse gas emission reductions, that application is eligible for this program. Now, there are some other restrictions on the program, just basically to prevent, I think, large companies from using this for all of their applications. But truly important innovations that meet that criteria. In my experience, that criteria has been pretty broadly or liberally interpreted. I haven't had a case where, and we've probably done 6 or 7 of these. I haven't had a case where we were denied, acceptance into the program because it didn't fit within that criteria. So, once the application qualifies, basically it's moved to the front of the line and in the queue for examination. And, that process normally without this program can take a year, 2 years, 3 years, depending on the technical area. We've had cases where we have received a first office action from the U.S. Patent Office within 2 months, and actually had a client that was able to get a patent within about 5 months. So something that normally takes 2, 3, 4 years took 5 months.
That's pretty incredible. How important is it for some of these companies that these patents get approved?
Yeah, I mean it's critical. Certainly, you have some familiarity in this space. What we see a lot of clients say, especially startups, universities, that they need patents in order to get to get funding. When you're going into pitch a VC or a private equity firm looking for money, one of the first questions they'll ask is, what does your patent portfolio look like? They do it on Shark Tank too. I know it's probably a little overblown, but it really, rightly or wrongly, it really is one of the first questions that people ask is, do you have patents? Have you thought about those? And so this is a phenomenal way to say, yeah, you know, we not only have applied for them, but we've actually gotten one in 5, 6 months.
And that's more for like the protection of the IP. I mean, you reference Shark Tank, and that's really one of the things that they want. They want to be able to protect the IP. They want to make sure that nobody can copy this. That, I guess, for a young company is super important in terms of being able to raise funding, but also to make sure that their technology they know is protected, particularly in a age when it's so easy to copy.
Totally. And I think the best example of that is probably the Amazons, the world where you see, if you, and this is probably not so much relevant to clean tech, but you see the volume of counterfeit products that are on Amazon and pop up quickly on Amazon. And Amazon actually has a program that if you have patents, you can shut that down. But the counterfeiting is huge, and especially at a time where the U.S. is trying to, and other countries are trying to, I guess, get ahead of China and other countries. It's really critical that you have, that you're protecting yourself against counterfeit products from outside of your country.
I mean, you mentioned China, and I know that, for example, a lot of the European car companies had big problems in China because, a lot of the Chinese companies now they make their own cars and they're fantastic. But before they were sort of wholesale copying the European cars and maybe changing the name. And therefore the Chinese courts were like, oh, well, this is fine. And we don't think this is patent infringement. How does this go in terms of protecting those patents? If there was somebody that was wanted to copy it, how far does this go in protecting that?
Yeah, that's a really good question. And unfortunately, since patents are really a national right, a U.S. or German patent will only protect you in the U.S. or Germany. And so it is somewhat incumbent on companies to file for protection in other countries as well, wherever they might manufacture, where they're going to sell, where there's big markets. A lot of times just filing in a couple of the major regions or countries is sufficient. But it's really interesting because China has of course become a leader in a lot of this clean tech innovation with solar panels and batteries. So we see that, that where we have clients that are Chinese companies that file for clean tech innovation, and they've got some good stuff, and so it does create a really interesting dynamic. But I think the best companies can do is really just think about where you're going to sell, where you're going to manufacture, and since money is finite, you just have to try and obtain patents in a couple of those places to give you as much protection as possible.
I mean, that's quite interesting. You saying that you've got Chinese companies coming to America to apply for patents in America to make sure that their technology is protected.
Mm-hmm.
Because yeah, they are the leaders in especially when it comes to solar panels and a lot of the other devices they've pumped in, and they're largely responsible for the drop in price. The program was extended by a couple of years. Was that due to? I mean, I know that you're not a representative of the patent office, so me asking you these questions is maybe unfair. But I'm curious whether if that was as a result of overwhelming demand or a lack of demand.
Yeah, that it's really interesting. It just my colleague and I just did kind of I don't know, an informal study on this within the last month, where we tried to look at applications where requests to participate in this program have been granted or denied. And we've seen, so basically the program allows for a total of 4,000 applications within this 5-year period. If you had more than 4,000 applications qualify within 3 years, then the program would be scheduled to terminate. But what we've found is in just over, so it was launched in June of 2022, and so we're in October of 2024. We only see about 400 or 500 granted petitions in a little over 2 years. Now, the tricky part is that patent applications don't publish right away. There is a lag, and so it's likely that there's more than 400 or 500 petitions that have been granted. But still, that seems to me to suggest this is heavily underutilized. In almost 2.5 years, only 400 or 500 applications just doesn't strike me as being indicative of a huge demand, and I don't really know why. It's a bit
Yeah, I mean,
puzzling.
I mean, partly I wonder if people know about the program and they know that they can do this, because I know being a startup founder myself, um, people are when you hear about going through a patent application process, it tends to be laborious, time consuming, expensive, all of these negative externalities. And so a lot of times, founders are just like, let's just get it done if we, and then we'll worry about the patents later. Is there any advice that you might have as a lawyer to people that kind of take that approach?
Yeah, I mean, it's a really good point. It's something we see in all areas, not just clean tech, but that's definitely that's definitely a reality. That well, there is limited money and there's limited time, and sometimes you're so excited and you want to push things forward, and you're trying to get money, or you're trying to get something to market, or the danger that companies face is if publicly disclose your invention. Let's say you have a patentable invention and you publicly disclose it. Basically, you can lose rights to ever being able to protect that with a patent, if sufficient time passes. Probably the greater concern is that someone else takes your invention, um, you know, whether that's through a meeting with them or a publication, a journal article, or they see the product and then they try and go get a patent themselves. Now they may face difficulty depending how much you've disclosed, and for how long ago you disclosed that. But yeah, I think that's the real difficulty, and actually that's where we've seen in the past where some Chinese manufacturers were able to basically take inventions from Western companies, and the Western companies didn't do a sufficient enough job of protecting that, and the Chinese manufacturer was able to obtain a patent on it, and so then they're in the driver's seat. So you really just need to be careful, when you're getting to the point where you're disclosing it to other people that are kind of outside of the company, and there are things you can do to you can file what's called the U.S. provisional application. I don't think too many other countries have this available, but it's basically an application that's not published, it's not examined, there's very few formal requirements, and it just allows you to get something on paper, get your kind of plant your flag in the sand, and gives you 12 months to see what the market is, see if you can raise money, see if there's a viable path forward. So that's typically what we recommend for clients in that position, that where they maybe don't have a ton of money, they're in a rush. Let's at least get something on file so somebody doesn't steal it and come back to bite you later on.
Tell me a bit about patent trolls. Have you ever, come across these people? What, how do they operate? I know that a lot of climate, I know that with patents there's a statute of limitations, right? So it's like after 50 years, if the patent is not renewed, I don't know if that's patents or music rights, I can't remember, but somebody can apply for the same patent and claim it. So now we're looking 50 years in the future for climate, but how do patent trolls work?
Yeah, so you're correct. You are thinking of, I guess, copyrights, where those are renewable after, and at least in the U.S., Congress has changed the term so often that I can't remember what the term is anymore. It's like it's the Disney exception, as some people call it, because it seems to correlate to Disney's copyrights on Mickey Mouse and all that. But anyways, that's an aside. Yeah, so patents are good for 20 years from the first earliest kind of priority date when you file for the very first time. And trolls are definitely a problem. We have clients that have been sued by trolls that and the word troll has a lot of different meanings to different people, but I think generally the idea is that it's someone who didn't create the invention, someone who's not making a product or selling it, a process or a method or a service, and really they just have the patent for purposes of preventing other people from doing anything with it, and then they sue on it. And so a lot of the big tech companies have been been sued by a lot of trolls, and there have been some things in the U.S. that have been done to try and rein in trolls, and there's kind of like a constant pendulum that we go through where at times we've been probably too lax on patent trolls, and so they've kind of gummed up innovation, and then other times we've been really hard on them. The problem then is it maybe unintentionally prevents companies who are not trolls from monetizing patents. So it can be over inclusive or under inclusive, I guess. So I don't know, hopefully that kind of answers your question or gives you a little bit more info on.
Yeah, just it's interesting. I mean, it's amazing to see the different ways that people make money, and the fact that someone could think about this and conceptualize that this is a way that they could earn. And it's like an industry now. People just sit and watch, when these patents are expiring and to claim them. So it's quite interesting.
Yeah.
Have you seen tangible benefits with your clients that have used this program? Like, if they've been able to go to market faster, have they been able to raise money faster? I imagine that if a client like yours is engaging a lawyer, they're using you for more than just patents.
Yeah, so our firm does all sorts of IP and patents, trademarks, copyrights, but then also transactions. So we help clients obtain licenses where hopefully they can monetize their IP, and particularly university startups would be I mean, universities probably would be first and foremost there. They typically don't have the money or the wherewithal to, to monetize, take things to market. So we'll help there, and then we do have a litigation group that also helps folks enforce their IP rights. So the program, I guess, is so new that I haven't seen so much in the way of clients utilizing it and then immediately turning it into a license or some sort of royalty deal where they're getting money back. But what we've seen is that particularly clients that so one of the challenges with this, as I kind of alluded to earlier, is that basically in order to qualify, you can only be an inventor on one of these 12 times, and I don't know how they ended up picking the number 12, but so it does prevent inventors from serially being part of the climate change mitigation program. And so what we typically see is clients will pick very important or strategic inventions and use this for that, because you really can't use it for all of your inventions. It just doesn't work unless you just have so many different inventors that you can use. But anyways, so I think that's typically where we've seen it, and it does seem to be beneficial to providing companies with protection for their really important inventions. And actually, I've seen it more used by medium-sized to larger companies, less so from startups. And I guess that goes back to the kind of the question you raised earlier, or the discussion we had earlier about do startups not know about it? Is it just why is it underutilized? I guess is really the question. I don't know. But anecdotally, it does seem like it's very underutilized by startups and smaller companies.
Well, what advice would you give to companies that are thinking about utilizing this program?
Well, I think first and foremost, the program is free. So, and it's not too many things that are free these days. And it's something that can, if you were to file a request to have accelerated examination, so basically to have your application moved to the front of the queue, that normally costs a big company, a large entity, $4,000, a small entity, $2,000. And so, you can already see by utilizing this program, you can save a couple $1,000s. And the other benefit I see to this program a lot of times is typically it's staffed with very experienced examiners at the U.S. Patent Office, and a lot of times they're willing to work with you to help you obtain a patent as quickly and as cost effectively as possible. And so overall costs, in my experience, also tend to be lower when you participate in these types of programs. So you're not only saving money on the accelerated portion, but the fees that go with the patent process, which can be daunting, are typically reduced when you participate in this program. So, to me, it's a no-brainer. If you've got something that's important that qualifies as, addressing climate change or mitigating climate change, unless you're just trying to drag things out. And then there are instances in which that can be valuable, that, you want something pending as long as possible, see if the market will develop. But if you're ready and you've got a market there, or you've got, funding, or you need funding, I would say, use this program. It's free, and it'll save you money, and it'll get you patents, or at least a patent, as soon as possible.
So my last question is about the sort of latest buzzword that's going around, because I think in some reading I read that the program encourages you for patent protection for AI powered technologies that are addressing climate change. And I guess, what are the challenges in securing patents for AI? Like, how do you do that?
Yeah, that's a really good question, and I have some colleagues in the in our computer and electrical technologies group that deal with AI all the time, because of course AI is in just about everything we do now, everything we see. I did a kind of a little digging for an article a few months ago about the use of AI in recycling, and how companies, startups are actually trying to use AI to more efficiently and cost effectively, recycle things, sort things. Um, and there's companies are doing some really cool stuff out there that I think, I'm hoping will allow us to really address I guess the waste problems we have, and, landfills being filled with garbage and stuff we should be able to recycle, but we can't, or, somebody sorted it wrong, or it was, somebody didn't follow instructions. Like, there's so many things that can go wrong to prevent us from actually recycling things. And some of those companies have gotten patents on their different systems. The one thing I'll say, that the challenge with AI is, at the beginning, and this is true of additive manufacturing as well, which is something, I see a lot of. When it first broke in, it was something very new, and it was much easier to get patents on 3D printed parts, because you'd never seen these parts with shapes and passageways and sizes. But now it's just much more difficult, because the process is pretty standard. The 3D printing process, just like AI, has become, much more well understood. And so you really you kind of need a tangible hook. And so a lot of these patents I saw had to do with robotics. So, it's a robot that's using AI. And so, the AI is causing the robot to do this, which then, feeds into another robot, or some other part of the system. And
Which
that's
goes
where
back to your recycling example, because that's what I imagine. You've got a vision AI that's looking at it and picking out the pieces, and that's telling a robot to, like, these are the pieces that to pick out and where to place them. I've
exactly.
seen sort of similar technology. Yeah.
Yeah, exactly. And that is what is going to be more likely to be patent protectable than just the AI itself, or just the code, the algorithm that's determining what to pick out or not.
Amazing, Ryan. This has been super informative, and hopefully, several of the listeners, it gives them something to think about and to consider going and actually going for this application. Just finally, is this open only to U.S. registered companies, or if you're a business that wants to sell in the U.S., is this open to you as well?
Yeah, that's a good question. No, there's no restrictions as far as geographical locations. So it doesn't matter if it's a U.S. company. Actually, the one situation I mentioned earlier, where we got a patent for a client in 5 months using this program, it was an Israeli company, and so yeah, it's open to anyone across the world. Really, the only qualification or constraint is just that you can only have inventors named 12 times as part of this program. But otherwise, there's really no other kind of meaningful restrictions. So yeah,